Oyez, oyez, oyez. The Court of Appeals for the Fourth Judicial Appellate District is now open pursuant to call.
Good morning, everyone. Welcome to the Fourth Court of Appeals. At this time, the current environment precludes us from holding live arguments in our courtroom at the Cadena Reeves Justice Center here in San Antonio. The court welcomes the advocates on this Zoom virtual platform, as well as the interested parties and general public viewing these proceedings as we live stream on the Fourth Court's YouTube channel. Please be aware that should we suffer any unforeseen technical difficulties, I will stop the clock. If necessary, I may temporarily suspend the proceedings and the judges will recess briefly. Our clerk of court, Mr. Michael Cruz, will provide you with further instructions and assistance as needed. Once resolved, I will resume the hearing and counsel will proceed for the time that remains allotted to his or her side. As you know, on May 8th, the Office of Court Administration suffered some ransomware, but we have hurdled those, much to the credit of our current chief and our clerk. Please be assured that this panel has the complete briefing and appellate record and is fully prepared to submit the case and to issue a judgment and opinion accordingly. In light of the virtual nature of these proceedings, I wish to provide you with some guidance to help you navigate through the panel's questions this morning. The justices have decided to raise their hand like so when she wishes to ask a question. I may have to verbally and politely interrupt you should your attention veer away too long from the screen. At this time, beginning with counsel for appellants, I call for announcements in cause number 0420-302CV, and forgive me if I slaughter your name, Susan Janicek Poller et al. Versus M&L Minerals LP et al. Counsel.
Good morning, Elizabeth Kopetsky for the appellants, and I have in the room with me co-counsel Clinton Butler and Catherine Stone.
Good morning. Counsel for appellees.
Calhoun Bobbitt for the appellees, and I'm joined by my partner, James Drought, and my partner and technical advisor, Matt Batters.
Good morning. As you know, you each have 20 minutes to make your respective arguments. An appellant will have 10 minutes for rebuttal. Appellant counsel, you may proceed.
May it please the court. This case involves a narrow issue of deed interpretation regarding the effect of a subject to clause contained in a general warranty deed that was executed in 1977 by two of the Mechagamba appellees and their predecessors as grantors. The Janicek appellants are the successors of the grantees in the 1977 deed. The Mechagambas claim the subject to clause acted as an exception, thereby preventing certain royalty interests from being conveyed to the Janiceks. However, the clear terms of the 1977 deed and the precedent established by this court in Gonzalez and Drzumbic foreclose the interpretation requested by the Mechagambas. The parties agree that the 1977 deed is unambiguous, so they filed cross motions for summary judgment. The trial court granted the Mechagambas motion and denied the Janicek's motion. In doing so, the trial court construed the 1977 deed to mean what the Mechagambas claim it was intended to state, not what was actually contained in the deed, which is contrary to well-established Texas law. Because the 1977 deed is unambiguous, the primary duty of a court is to ascertain the party's intent from all of the language contained within its four corners. Before diving into the facts of this case, it is important to keep in mind that Texas law requires exceptions to be made by clear language. This court in Gonzalez stated that exceptions, which are generally strictly construed against the grantor, must identify with reasonable certainty the property to be accepted from the larger conveyance. The 1977 deed does not identify any property that is accepted from the larger conveyance, other than a life estate in Susan Janasek, which we will discuss in a minute. This court is once again presented with the opportunity to reaffirm that subject to language such as that contained in the 1977 deed does not operate to accept an interest in the grantor. The royalty interests at issue were created in several instruments. First, on July 11th, 1958, a 1/4 royalty interest was conveyed to Ruskin C. Norman for 10 years and as long thereafter as there was production. The parties have referred to this as the Norman interest. Then on July 17th, 1959, a 1/8 royalty interest was conveyed to M.T. Buckaloo Jr. for 10 years and as long thereafter as there was production. The parties have referred to this as the Buckaloo interest. Finally, on September 26, 1959, each of the grantors in the 1977 deed was conveyed a 1/24 royalty interest from their parents. The parties agree that the Norman and Buckaloo interests were outstanding at the time the 1977 deed was executed, but that they are presently terminated for non-production. I will collectively refer to the Norman, Buckaloo, and the 1/24 royalty interests as the disputed royalties. Now, the 1977 deed conveys to the Janaseks all that certain tract or parcel of land, and then the legal description is followed by a subject to clause, which makes up the entirety of the parties' dispute. Now, the subject to clause will likely look familiar to this court as it recently reviewed identical language in Jerzumbic versus Marathon Oil. The deed provisions at issue in Jerzumbic are virtually identical to the clauses in the 1977 deed that the Machagambas rely on. Further, the Jerzumbic deed was executed only 1 year before the deed at issue in this case. Because this court determined the clauses relied on by the Machagambas were insufficient to reserve or accept an interest in favor of the grantors, Jerzumbic is dispositive. The issue in Jerzumbic was whether the grantors conveyed or retained their possibility of reverter. Stated another way, the grantors owned the possibility of reverter before they executed the Jerzumbic deed, just like the Machagambas did here before they executed the 1977 deed. Now, the subject to clause, which is the center of the dispute, contained in the 1977 deed, provides, this conveyance is subject, however, to all mineral conveyances, mineral reservations, oil, gas, and other mineral leases, royalty conveyances or reservations, easements, ordinances, and rights-of-way of record in the office of the County Clerk of Karnes County, Texas. The only difference between the subject to clause in the 1977 deed and the subject to clause in Jerzumbic is the first word. After explaining that no authorities were cited showing how the subject to clause accepts or reserves the possibility of reverter in the grantor, the Jerzumbic court determined the subject to clause was not a clear intention to reserve or accept an interest from the conveyance and refused to imply a reservation in favor of the grantor. The Jerzumbic court also explained that the principal function of a subject to clause in a deed is to protect a grantor against a claim for breach of warranty when some mineral interest is already outstanding. Here, the Norman and Buckaloo interests were outstanding at the time the 1977 deed was executed. So the subject to clause had to be included, or the grantors would have breached their warranty immediately upon signing the deed. After the subject to clause is a brief introduction to Susan Janasek's life estate reservation, which states, in addition to the above exceptions. Now this phrase, together with two references in the habendum clause that provide the conveyance and warranty are subject to the above mentioned exceptions and reservations, form the sole basis for the Machagambas' claim that the subject to clause serves as an exception of the disputed royalties. However, the Machagambas' position is not supported by Texas law or the terms of the 1977 deed. In fact, the terms of the 1977 deed demonstrate that the parties knew how to effectively exclude an interest from the conveyance by the words they used when creating the life estate in Susan Janasek. Specifically, they provided that there is reserved and accepted unto Susan Yanasek an undivided 1/4 interest. The 1/4 royalty interest reserved by Susan Yanasek terminated upon her death on May 6, 1983, and the remainder interest following expiration of the life estate is not in dispute. Further, the same introductory clause was present in the deed in Drzumbic, and although it was not argued that use of the word exceptions changed the effect of the preceding subject to clause, this court determined that the deed failed to express a clear intention to reserve or accept the possibility of reverter from the grant.
So, Ms. Kopecki, I have a question. If we understand what the Machigimbas, what the trial court interpreted that the Machigimbas were attempting to do, is it your position that they should have just used parallel language as they used in Susan Yanasek's reservation?
In order to accept those interests from the conveyance?
Correct.
It's our position that they needed to meet the definition of what Texas law requires for a valid exception. And that is that it specifically or with reasonable certainty identify the property to be excluded from the conveyance. And there is no language such as a save and accept clause or a less however, or any language like that that you can look to as providing some evidence that there was an intent to keep some property from passing under the terms of the grant.
Thank you.
So finally, the habendum clause in the 1977 deed contains language that is virtually identical to the clause in the deed at issue in Drzumbic. Specifically, both deeds state that the conveyance is subject to the above mentioned exceptions and reservations, and the warranty is subject to the above mentioned exceptions and reservations. After the Drzumbic court explained that the Texas Supreme Court's opinion in Bass versus Harper does not support the argument that the clause reserved the reversionary interest, this court pointed out that the deed in Drzumbic could have used a save and accept clause or equivalent language to reserve the future interest. The Drzumbic court went on to explain that save and accept clauses were used for decades before the deed was drafted in 1976. Yet the deed did not use a save and accept clause or other equally clear language that would have had the same effect. Therefore, because use of subject to in the habendum clause only applied to the warranty, the sole purpose of the subject to clause in Drzumbic was to provide the grantees with notice that there were interests outstanding in third parties. That same conclusion should be reached here. The life estate reservation is the first and only time the 1977 deed evidences an intent to reserve or accept an interest in favor of one of the grantors. Stated another way, there is no clear language creating an exception or reservation in the 1977 deed other than the life estate reservation in favor of Susan Yanasek. Without clear language reserving or accepting the disputed royalties from the conveyance, the 1977 deed must be read as conveying the greatest estate possible to the grantees. As this court concisely stated in Drzumbic, unless a general warranty deed's plain language clearly shows an intention to convey a lesser interest, we will construe the deed to confer upon the grantee the greatest estate that the terms of the instrument will permit. In other words, a warranty deed will pass all of the estate owned by the grantor at the time of the conveyance unless there are reservations or exceptions which reduce the estate conveyed. So what did the Machigambas own at the time the 1977 deed was executed? Well, they owned the 1/24th royalty interests and the reversionary interest in the Norman and Buccaloo interests. Because the Machigambas did not reserve or accept the 1/24th royalty interests or the reversionary interest in the Norman and Buccaloo interests, those interests were conveyed to the Yanaseks in the 1977 deed. In Gonzalez versus Jansen, this court concluded that two deeds failed to exclude a reversionary interest from the grant. There, both deeds conveyed all of the property, subject to the deed in which a reversionary interest was created, and subject to a deed in which the grantor's father conveyed the royalty interest to the grantor and his siblings. This is a very similar situation to that before the court today. The only difference is that the Gonzalez deed contained specific references to the deeds in its subject to clause, whereas the 1977 deed generally references all instruments of record in the clerk's office. In Gonzalez, the grantor argued that the subject to clause was the functional equivalent of an exception, just like the Muchagambas assert today. However, this court rejected that argument and stated that the deeds did not contain any clear and specific language to exclude the reversionary interest from the conveyances. The Gonzalez court went on to acknowledge that magic words are not required to exclude a reversionary interest from a conveyance, but some language is required to show that a grantor is retaining and not conveying it.
Counsel, how would you respond to the appellee's argument that we may wish to consider the term royalty interest separate from the 1/24th royalty interest?
Those interests should be treated the same. They were both owned by the grantors at the time that they executed the 1977 deed. And so Texas law requires that in order to prevent those interests from passing under the terms of the grant, you have to include an exception or a reservation. So just like in Drzembeck, the Gonzalez court also refused to apply Bass versus Harper, citing the Texas Supreme Court's opinion in Winsk versus Ely, wherein Bass was limited to the specific wording of the instrument in that case. Therefore, unless an instrument specifically states this grant is subject to, Bass does not apply. In Piranha Partners versus Newhoff, the Texas Supreme Court explained two ways in which a grantor can retain property. A grantor may withhold for itself a part of its estate either by granting the entire estate but reserving the portion it desires to retain, or by granting only the portion it desires to convey. Here, the 1977 deed granted the entire estate, and the only part that was held back by the grantors was the life estate in Susan Yanosek. The 1977 deed presents the same issues this court has already decided in Drzembeck and Gonzalez. First, the 1977 deed contains identical language to that before the court in Drzembeck. For that reason alone, the 1977 deed should be interpreted as conveying the disputed royalties to the Yanoseks. Second, the Muchagambas owned the reversionary interest and the 1/24th royalties at the time they executed the 1977 deed, just like the grantors did in Gonzalez and Drzembeck. Because the Muchagambas failed to reserve or accept the disputed royalties from the conveyance, and because the subject to clause does not act as a reservation or exception under Drzembeck, the 1977 deed must be read as conveying the greatest estate possible to the Yanoseks.
So you would then consider the appellee's argument that unlike in Gonzalez, which they attempt to distinguish from this case, in Gonzalez, that deed used the word all in both the granting clause and the property description. Here, it is contained only in the description of the property. Do you consider that insignificant difference, and why, and what support would you have to address that issue?
So first of all, the granting clause in the 1977 deed purports to convey all of the property. So to hold any part of that property back, there must have been a reservation or an exception. And second, that issue was not determinative in Gonzalez. Gonzalez based its decision on the fact that there were no clear, reservations or exceptions of the interest. And so, that fact.
The Gonzalez court highlighted the fact that the word all was in both the granting clause and the property description.
That's correct. That's correct, Your Honor.
And emphasize that was within the four corners of the deed, more of a reflection of intent to do so, to convey the entirety of the property.
That's correct. And we have that same, we might not have the use of the word all twice in the 1977 deed, but it is there. It grants and conveys all of that tract of land. So all of the grantor's interest in that property is conveyed. So then you have to look at the remaining provisions in the deed to see if there is any clear evidence of an intention to reserve or accept an interest. And there simply is none. So third, the language in Gonzalez and Drzumbic that discusses.
Forgive me, Justice Rodriguez has a question.
Sorry, I had a question, Ms. Kopecki. Can you speak to the paragraph following the reservation of the life estate to Susan Janasek? Specifically the first sentence where it talks about to have and to hold the above described premises subject to the above mentioned exceptions and reservations. What else would that be referring to? Can you speak to that?
Yes, so actually Drzumbic versus Marathon Oil answers that question. So in that case, the portion of the 1977 deed that you're referencing is called the third and fourth uses in that case. And there they say that they refer to any exceptions or reservations that were stated in the 1976 deeds preceding paragraph. So it says that those references themselves do not actually reserve the possibility of reverter from the grant, but that there was no other language in the deed to reserve or accept an interest. So basically what I gather from Drzumbic is that those references were not themselves effective to reserve or accept an interest and didn't reference anything since there were no other clauses in the deed that reserved or accepted an interest. And further, the warranty clause does not enlarge the grant. So those were simply put in there to protect the grantor from a breach of the warranty. So finally, the language in Gonzalez and Drzumbic that discusses other purposes for a subject to clause refers to Winsk versus Ely, wherein the court addressed Bass versus Harper and its limited application to the facts of that case. Therefore, because the 1977 deed does not contain the specific wording that the deed in Bass had, Bass is inapplicable. So the Janaseks are here today asking that this court follow its well-reasoned opinions in Drzumbic and Gonzalez and hold that the 1977 deed does not contain any clear language to reserve or accept the disputed royalties from the grant. This is the only construction of the 1977 deed that gives meaning to all of its words and phrases and does not add terms to the parties' agreement. The Janaseks respectfully ask that this court reverse the trial court's judgment and render judgment in favor of the Janaseks.
Thank you, counsel. Counsel for Appellees.
May it please the court. The appellees in this case are 8 of the 9 children of Ed and Susan Janasek, or their successors, who with their mother Susan were the grantors of the 1977 deed to Vincent, their brother. The dispute began in 2018 when the current lessees of the property issued new division orders, which for some recently completed wells, which credited the royalty interests, which had previously been credited to the appellees under at least 2 previous operators, and division orders had been issued, royalties paid on the basis for which we contend here. We fully recognize that our task here today is to persuade the court that the same general principles upon which Drzumbic and Gonzalez were decided must lead to a different result in this case. Justice Martinez was a member of the panel in both of those cases, Justice Rodriguez and Jarzambek, I believe. And so the court obviously has some familiarity with the issues, and in 2018 and 2019 has decided that subject to clauses in those cases did not accept the interests involved. And so Your Honor, yes.
Let's cut to the chase. What authority would you bring to the court that would permit it to look at what is essentially parole evidence regarding the past conveyances, the prior conveyance practices, and the fact that the royalty interests were not in dispute until recently, to allow us to consider that evidence outside the four corners rule?
Well, Your Honor,
through the intent of the grantor.
well, Your Honor, we've cited Sunoil versus Madeley for the proposition that the court can consider surrounding circumstances. We've cited Forrester versus Coleman and another case for the proposition that the party's own interpretation over the years is a surrounding circumstance which may be considered. However, I don't want to overemphasize here the surrounding circumstances argument. They certainly support our construction of the deed, but they are not the basis for it. The basis for it, as you say, to cut to the chase, is that both Jarzambek and Gonzalez and the Winsky versus Early Supreme Court case, which they cite, primarily base their reasoning upon the concept that a subject to clause is usually used to protect the warranty. Most of counsel's discussion this morning, predictably, was confined to 2 of the 11 interests that are under discussion here. The term royalty interests, which were outstanding in third parties. The 9 1/24 royalty interests were completely owned by the siblings. There was no outstanding interest in any third party. Therefore, the subject to clause, including those interests, could not possibly have served the function to protect the warranty, which was critical in Jarzambek and Gonzalez. If the intent had been to convey those 1/24 royalty interests, then the deed would not have been made subject to them, and they would have unquestionably passed with the grant under the rule that Ms. Kopecky cites, which is you will construe a deed to pass the greatest estate that it can. It is simply nonsensical for a grantor who owns an interest in the property being conveyed, or who owns separate interests. And I might mention that Ms. Kopecky asked the question, well, what did the Moxagimbas own at the time of the conveyance? And she left one interest out. And we think that, again, it demonstrates the intent of this deed. The siblings all owned remainder interests in the surface of the property to follow their mother Susan's death. And so our contention is what the intent of the deed was to convey the farm to one of the brothers, Vincent, while to leave in place the equal ownership among the family, among all the siblings. Yes.
No, please finish.
The equal ownership of all the siblings in the minerals as had been done throughout the history of this family.
So how would you respond in their reply brief? The appellants raise concern about the argument you just shared. One flaw being that the term royalty interest at the time the 1977 deed was executed, that there were in fact third parties that were also entitled to some royalty interests. How would you respond?
Well, I would respond as we did in our brief by acknowledging that there is some difference, that if the only interests that we were involved with here were the 2 out of 11 interests, which were term royalty interests, then the case would be closer to Jarzombek, although I propose to distinguish even that. But so as to those 2 interests, yes, the subject to clause could have served the purpose of protecting the warranty. That's true. It could not have as to the other 9 royalty interests. It's contraindicated. It's exactly what you would not do if the intent was to convey those interests, because it would have been done without including them in the subject to clause, and putting them in the subject to clause could do nothing but confuse the grant. Now, and I think
To that same point again, I think there may be the Januseks also argue that the protect the warranty argument would require, again, that this court construe the deed by looking outside into some of this extrinsic evidence you wish the court to consider to determine whether or not these existing interests were held by third parties or not, even to a varying degree, or to a lesser degree rather. What authority would you provide? Because this was something raised in their reply brief and I didn't see anything in response particularly to that point, but if you could address that. Again, what authority allowing us to consider the extrinsic evidence that you wish the court to consider to distinguish our rulings, our previous rulings?
Well, Justice Martinez, we're not relying on any extrinsic evidence in that regard. We don't need any extrinsic evidence to show that the 9 1/24 royalty interests were not subject to any interest in any third party. They were completely owned and vested perpetual royalties, which were held by the siblings under the 1959 deeds. I believe what they if I recall what you may be referring to, I believe they said that in Jarzombek, actually Gonzalez, I think, that was subject to 4 term royalty interests, which were still outstanding in third parties, and the deed there was made subject to a 4/5 term royalty interest. And they argue in their reply brief that this meant that the grantors didn't own an interest. Well, they did. They owned the reversion.
To be clear, just so that we're on the same wavelength, the extrinsic evidence, I think what appellees invite us to consider are the family's prior conveyance practices.
Well, I think the court is entitled to consider them. I mean, I've cited the two cases. I mean, the family unquestionably had a history in all of its transactions in maintaining equal ownership in Ed and Susan's children, the nine siblings. But again, I want to stress that we don't rest our case on that. It tends to confirm the construction of the deed, which should be reached from its four corners. And with the time I have left, first of all, I think we've shown that the major underpinning of Jarzembek and Gonzalez was the protect the warranty concept, which cannot possibly support a reversal of this case, at least as to the 1/24 royalty conveyances, because it just cannot be argued to apply. Now, what's the next thing? All the cases, and counsel cited Gonzalez, that says there must be some language to indicate an intent to accept that the subject to clause is to act as an exception. Well, in this deed, I don't see how it could be any plainer. First of all, you have the grant, which, as you've correctly pointed out, and I don't think Ms. Kopecky quite got it right, that the granting clause does not say all the property. And the court devoted several paragraphs, over more than a page of its opinion in Gonzalez, to the presence of that word in the granting clause. The only place in the 1977 deed where the word all is used is in the property description. Well, the property description is just describing the tract, and it makes clear that this is a 200 tract. This deed doesn't just apply to 100 acres. It applies to all of it. But the granting clause doesn't say that it's conveying all of it. So that is another key distinction. Now, another thing that they say, and Ms. Kopecky said it this morning, is that, well, since they had a reservation clause for Susan, the mother, they knew how to reserve an interest. Well, again, the Gonzalez case goes into a discussion of the difference between a reservation and an exception. And what Susan did was quite properly a reservation, and what the remaining grantors did was quite properly an exception. And the structure of the deed confirms that, because when it first says, after the granting clause, that the grant is subject to the above exceptions. Okay, those are the exceptions contained in the subject to clause. The next time it refers, and this is in the habendum clause, it says subject to the above reservation and exceptions. So yes, indeed, they did know the difference between the two. And when there were only exceptions above the reference in the deed, they said exceptions. when there was a reservation and exceptions above the clause in the deed, they said it that way. They said reservations and exceptions.
And I would I certainly agree with you, counsel, that in construing a deed, we look particularly to the language of that particular deed. And while I agree, while both cases handed down by this court are not going to be directly, that this case won't be directly controlled by Gonzalez and Jarmazek, we do need to give this deed a particular construction. And so in pointing out, these distinctions between the reservation and exception, we did in the Jarmazek case can be instructive because we had the same similar language in that case as we do in this case. And in Jarmazek, we, even though those paragraphs did not establish an exception because the language, we held that the language did not establish an exception because the language didn't express a quote, a clear intent to reserve or accept the future interest from the grant. And so, well, I think it's undisputed that in this deed, the paragraph that follows the subject to paragraph, that it creates a reservation for Susan Janasek. I think there might be, is there something that you see that construes both an exception and reservation as synonymous?
And as the Gonzalez case says, reservations and exceptions are not synonymous.
In fact, you hold it, this distinction is pretty important. And while your construction of this particular language is reasonable, the reading contended by the appellants are also somewhat reasonable. So if the construction by both sides are reasonable, how would you argue or submit to this court, other than, of course, an affirmance, to harmonize the remaining part of the deed to show that the intent was, as you argue, for purposes of this, the structure taken in this deed? So the rest of the deed, what else in the deed could you point to that would allow us to read this deed in harmony with the remaining provisions of the deed without going again outside the four corners of the deed?
Well, we'll stay right inside the four corners of the deed. The granting clause doesn't contain the word all. The primary reason for the holdings in Gonzalez and Jarmazek that the subject to clause was to protect the warranty is entirely absent in the deed in question is denying of the interests involved. And the Jarmazek deed has two subject to clauses, one of which specifically mentions the 4/5 royalty interests, which had to be made subject to protect the warranty and could not have been conveyed by the grantor. So we would ask that the court affirm the judgment of the district court. Thank you.
Any questions, counsel, justices? Very good. Thank you, counsel. Counsel for appellant, you have 10 minutes rebuttal.
May it please the court. Your honors, let's take a step back and remember a couple of rules of just basic deed construction that appellees have completely ignored in their argument. First of all, we read a deed to convey the greatest estate possible to the grantee. That means that if Justice Martinez, as you stated, if there are two reasonable interpretations, the rules of construction would state that we read that deed in favor of the grantee. We do not believe there are two reasonable constructions. We believe that Jerzombic in this case is so controlling that we could basically just stand here for the rest of the 10 minutes and read it. Because the same clauses that are contained in Jerzombic that were analyzed by this very court in Jerzombic persist in this case. The same circumstances that existed in Jerzombic persist in this case. In Jerzombic, the court looked at the exact same sort of subject to language and found that there is nothing in that language that evidences a clear intent to reserve or accept from the conveyance any portion of the grantee's mineral interest. Now, that doesn't matter if that interest is a reversion interest, a remainder interest, or a presently held fee simple interest. Interest in oil and gas have to be specifically, clearly, and unambiguously reserved or accepted in order to not pass with the estate. In this case, there is nothing in that subject to clause which indicates that grantees are reserving or accepting for themselves the interest. The subject to clause, as this court clearly stated in Jerzombic, is for the purpose of protecting for a breach of warranty against outstanding interest that would not pass pursuant to this document. The deed in Jerzombic, or the deed in 1977 that is subject to this case, does pass all of the property. And I'll read it to the court. Have granted, sold, and conveyed, and by these presents do grant and sell and convey unto Vincent Janasek and wife Leonasek the following described property situated in Karnes County, Texas. The described property is all of that certain tract. So the word all is in the granting clause because the description of the property is incorporated into the granting clause. The word all that certain tract is brought into the granting clause because that is the following described property. And Justice Martinez, long ago, you and I heard the Dubnik versus Hermes case. And in that case, one of the key elements of that case was the incorporation of a surface limitation found in the property description into the granting clause. It was that limitation that we brought into the granting clause because it was incorporated by the language of the granting clause. Same thing occurs here. That incorporation of all that certain tract of land brings right into the granting clause because that's the following described property. The court in Jerzombic then goes on and looks at the language contained in the next paragraph, which is that subject to the reservations and exceptions contained herein. Same thing that's in the paragraph for the reservation for Susan. And in that case, the court again held the sixth paragraph does not state a clear intention to withhold any interest. Again, there is nothing in addition to the above exceptions that evidences a clear intent to reserve or accept any interest, whether it's a reversionary interest, whether it's remainder interest, whether it's a fee simple interest. There's no intent contained in that document to show that they're going to withhold something. And then finally, the last subject to language is found in the warranty clause. And as this court stated in Jerzombic, the warranty clause is a separate covenant from the grant. It's not part of the conveyance. It does not strengthen, enlarge, or limit any portion of the grant. It only serves to protect title and to protect against a breach of warranty case. And in this case, it was very necessary for the grantors to have a subject to clause, which, as this court held in Jerzombic, is the general purpose of a subject to clause to protect against breach of warranty. At the time of the 1977 conveyance, the Norman interest and the Buckaloo interest were outstanding. If these grantors had signed this deed without that subject to clause, because of those two outstanding interests, the grantors in this case would have breached their warranty the very moment pen hit paper on this deed. So the intent behind the subject to clause is clear because there were outstanding interests. There was, as the subject to clause states, a mineral conveyance of record in Karnes County that was outstanding. It was outstanding in a third party who was not a party to the grant, who was not a grantor, who was not conveying all of his interest in that tract. And therefore, in order to protect the grantors against a breach of warranty case, they had to include a subject to clause. Without that subject to clause, they're in breach right then because the Norman interest was outstanding, the Buckaloo was outstanding, and therefore the grantors in this case were not capable of assigning all of that certain tract of land. It was all of that certain tract of land subject to these prior reservations and conveyances in Norman and Buckaloo. Justice Watkins?
I have a question. Does the word "and" in that last clause that we've been talking about, does the word "and" there give you any pause? Subject to the above mentioned exceptions and reservations?
No, it doesn't. Not at all. There's a poorly labeled word in there where it says exceptions. The subject to clause is not an exception. And as this court held in Combas versus Mustang Minerals, labels don't matter. It's the words that matter. It's the result of these words. It's the intent of the language that matters. Simply labeling something has no effect. And I'll quote the court here. Thus, labels given to clauses such as granting, warranty, addendum, and future lease do not control. Instead, we give effect to the substance of the unambiguous provisions. So what's the substance of that subject to clause? Well, it makes the deed subject to presently outstanding interest, and it prevents the grantees from having a breach of warranty claim against the grantors, because the grantors are notifying the grantees, look, there may be interest that we know about or don't know about, that we have subjective or constructive knowledge about, and therefore we are protecting ourselves. Yes, Justice Martinez. I believe you're on mute.
Thank you. So the appellees argue that, you know, this 1977 deed was a family transaction, that it was always the evident plan of the family to treat their children equally. There was no real, you know, concern about whether or not with Vincent suing them on their warranty. And so, and they point to Sun Oil and a couple of other cases to indicate that the court can consider those circumstances. Again, the circumstances surrounding the creation of the deed to support that interpretation. So why would it be unreasonable for the court not to consider those circumstances to show intent by the grantor?
I would cite the court to Piranha Partners. The court can look to surrounding circumstances so long as those surrounding circumstances do not expressly contradict or vary the terms of an unambiguous document. We have an unambiguous document here. There is nothing in this document that references any outstanding family agreement. There's nothing in here that would incorporate the parole evidence that, let's be very clear, that appellees rest their entire case on. The assertion that they can get away with their interpretation without having to constantly invoke parole evidence was contradicted by all the terms of their argument.
Yes. They're not going crazy there. They're just looking to say, look, I mean, the Supreme Court said we can consider the facts and circumstances surrounding the execution of a contract. Mm-hmm. And it's a simple aid in the construction of the contract's language. That's permitted by the Supreme Court in Sun Oil. So even if we were not to consider what may be construed as parole evidence, the joint will, all these other things. But given a reasonable interpretation by both readings submitted by both parties, why could we not consider those circumstances? Again, the facts and circumstances surrounding the construction of the contracts.
Because those facts and circumstances contradict the express terms of the language contained within the four corners of the deed. There is nothing in the four corners of the deed that limits or restricts the grant from the siblings to the Genesex. And so there's nothing that would need to be aided. There's nothing in this deed that cries out for, we need parole evidence or we need surrounding circumstances in order to aid the court's interpretation. The language contained within the four corners of this document speaks for itself. And therefore there is no further evidence that we need to seek. And I would cite this court again to the Dupnick versus Hermes case, and also to the Jensky versus Clausen case. Both those cases, family transactions, and especially the Clausen case, in which the Jensky tried to bring in. I'm sorry.
I'm sorry. Is it cited in your brief?
Yes, it's in our reply, Your Honor.
Very good. Since your time is up,
Very good.
we will refer to your brief and citations, and we will consider this case submitted. Thank you, counsel, for participating on this virtual oral argument. It's nice to see you both healthy and hopeful. So thank you again. Again, this case is submitted and an opinion will be forthcoming.